In this video, we're going to talk about one of the most important decisions a person who's charged with a crime has to make. Plea or trial? Let's get to it. Hi, I'm Javier La Torre. I'm an owner-director of La Torre Law in Tucson, Arizona, and I help people fight for their freedom and protect their future. Let's get on with the video. So first, let's talk about what is a plea agreement, right? Because the decision is a plea agreement or a trial, and we see all this on TV a lot, but what is a plea agreement? Well, it's kind of like a contract, but it's not really a contract, right? Because it's not like a private thing where you negotiate something with another person, a private person, you're going to pay me this or the other thing. But there is an exchange of a certain exchange of consideration, right? There's a certain exchange of things between the parties to a plea. Who are the parties to the plea? The state on one side and the defendant on the other. The judge is technically not a party, but if he accepts the plea, he's kind of bound by it. So in general, it is a negotiated agreement, right? It is an agreement where two parties, the state and the defendant, negotiate a non-trial resolution of a case, a criminal case, right? So for example, what are the defendant's choices? Well, the defendant has a right to a trial. Full-on trial, he has his right and day in court, guilty or not, he has that right? Now, the state, well, they have to prosecute the guy if they want to put him in jail or have some kind of consequences because of the issues that they are presenting. But the state has costs and the state has resources that the state needs to put into place in order to effectuate the prosecution. So the parties negotiate, well, the state says, well, I'm okay if you do less time or if you take a lesser charge, if that saves me the time and the resources of having to prosecute you, right? And then defendant says, well, I have a risk that if I go to trial, I might lose, right? So I do have an interest of, some certainty, right? What's going to happen in the end. So if you guarantee me this type of consequences, which is lesser than what I'm actually looking at, well then, I might waive my right to trial and just plead guilty, right? So basically the parties to the plea, they do mutual concessions of what they actually are entitled to, or at least procedurally speaking, they're entitled to, right? So a right to a trial, a right or a duty to prosecute, right? Technically to protect the community, right? So they do make mutual concessions, both parties, in order to not have to go to trial because both parties at risk of trial. The prosecutor also has a risk that he or she may lose a trial, but a good prosecutor doesn't really care about losing as much as he cares about protecting the community, right? To make justice prevail, right? So sometimes it's best when they don't have enough evidence on some charges to say, okay, take a lesser charge, we'll still put this person away, or at least put this person on probation and have this person be supervised instead of, the potential of the person being free and no supervision, right? If they lose. That's basically the nutshell of what it is. For a defendant, usually for the accused person, the major issue is certainty, right? Because going to trial, you don't know what's going to happen. It's always a risk. You can always lose, right? When a jury decides, or even a bench trial, if a judge decides, you don't know what that other person is going to think. So you want to limit your liability or your potential risk. So, well, take a lesser charge, a guarantee of probation, or a lesser sentence, a lesser range of sentence, a stipulated sentence, So that's basically what it is. But it's not exactly a contract, right? But it is kind of interpreted and in the nature of contract, but certain things don't apply. I mean, this is not a video on contractual law, but there's different ways. Rescission, the ways to undo a contract don't necessarily apply to a plea agreement, But what it is true is that once the court accepts a plea agreement, even the judge is bound by it, right? So the parties come in, once the parties have negotiated their respective parts, say, okay, I will give you this plea, you have this charge, plead to this other charge, we'll amend the charges, you can just take this other charge, which is lesser, we'll stipulate to a lesser range of sentence, availability of probation, for example, and you plead guilty, and then we're done, okay? And we don't have to do a trial. The judge still has to approve that. The judge does not have to approve the plea agreement, but if the judge approves it, he or she is bound by that plea. So the judge can't go beyond that plea. So for example, if there's a range of 1 to 2 years in the prison, the judge can't give more than the 2 years. Potentially he can give less than the 1 year, right? Because he's bound by it once he accepted it, right? So that's basically the nature of a plea bargaining process, basically, right? So why do we use plea agreements? Well, really it's a practical matter at heart. I mean, there's just too many cases and too many defendants and too many cases in the system. It's impossible to take them all to trial. That's just impossible, right? So prosecutors and the state in general prioritizes justice cases, right? So first-time offenders, non-violent offenders, first-timers, those people usually get breaks, right? Okay, we'll give you a lesser plea, or we won't prosecute you if you do all these things. Diversion, first-time, drug possession, usually on a non-dangerous drug or something like that. Stuff like that. People get a lot of breaks because you're a first-timer. You're not really a danger to society, at least not yet, right? So the state or the government, they prioritize prosecution. And some cases, sometimes they just don't prosecute, right? It's just not worth it because of the seriousness of the crime. So, clearly murder, big felonies like that. Yeah, they're going to go all the way. They might not even offer a plea, right? I mean, on higher level crimes like that, like class 1 felonies, even some class 2 felonies, in order to get a plea, sometimes, there's a panel that has to kind of consider, the facts, and you have to kind of say, okay, my client would plead to this or the other thing. So they prioritize prosecution based on the seriousness of the offense, and some offenses are more appropriate for plea agreement and negotiations, right? But in general, most criminal cases are resolved on a plea. So what are the advantages to the defendant for taking a plea offer? Well, usually you get a reduced charge. You avoid the uncertainty, right? You know what's going to happen, or at least to a certain degree. Sometimes we can stipulate to exact sentence, right? Other prosecutors won't stipulate to that. Some judges won't have it, right? It's just that, no, you can't hamper my ability to use my discretion in sentencing. You can do it in a certain way, like plead to a reduced charge or stuff like that, but certain stipulated sentences, some judges don't like them, other judges don't care. If you guys agreed, I don't care, I'll sign it. It just depends on the judge, right? There's reasons for that, but the judges have their discretion, right? Basically, for a defendant, the biggest issue is trial is always a risk. And also, it depends on how good your case is, right? Because, the better your case, maybe the lesser you want to take it to trial. But even if you have a perfect case, there's still a risk, right? There's still a risk that a jury's not going to like you, a jury's not going to believe you, and a jury's going to say, no, he did it, that's not true, I don't believe the alibi and stuff like that, and you can still lose, right? Granted, sometimes it's a lesser percentage of probability, but it's always there, right? It's always there, no matter how good the evidence is. So you're basically reducing that risk, right? But what are the factors? What should you consider when you're deciding whether to take a plea or go to trial? You need to sit down with your attorney to discuss that plea. You need to see what the strength of the evidence against you is. You need to see what the potential consequences are if you're convicted and what the benefits of taking the plea are for you, right? And then also you need to decide what your priorities are. So first of all, the strength of the evidence, right? So you need to sit down with your attorney. Your attorney will get discovery, and you have the right to see the discovery before you decide to take or reject the plea. If they offer you a plea, right? One of the things that you need to understand, though, is you don't have a right to a plea agreement. There is no right to a plea agreement. But once you get a plea agreement is offered, some rights are there. Basically, you have to be given a fair opportunity to consider whether to accept or reject that plea. You have to be given a fair opportunity to consult with counsel and with the effective assistance of your attorney. So basically, they have to disclose the evidence. They have to give you at least a good explanation of what the state's case is or the government's case is and tell you, okay, well, this is our case. This is what we're going to prove, and this is what we're going to prove it with. And then you sit down with your attorney and you go look at it. So if they have you on video, beating up some dude on an assault charge, well, you're probably going to lose that case, right? I mean, unless we can preclude the video because it was obtained illegally or something like that. They have you on video doing something, right? Or if you posted, if you're selling drugs online and and you're on video promoting your wares, I mean, it happens. So it just depends on how good the evidence is. I mean, I've had cases where I tell clients, dude, do not take this to trial. You're going to lose. You are going to lose. Let's negotiate something. There's no way we can win this. Other cases, I tell clients, this is fightable. This is worth it. I mean, if you want to take the risk, we can take it to trial. We can reject that plea and go forward. So it just depends on the evidence. You have to look at the evidence and discuss it with your attorney and make sure that you understand how strong or how weak it is. And then also to see if you have any defenses, that your attorney has prepared for you, right? So usually attorneys will prepare defenses, will do some investigation and, some impeachment of witnesses and stuff. And then based on that, you decide, analyze how strong that is and if that's worth taking it to trial or not. The other thing that you need to determine is your exposure at trial. This is kind of like a technical word of art that we use. What is your exposure? So you look at all your charges. Maybe you have some prior convictions or whatever. Your attorney has to go through all these charges with you, and he explains to you, okay, if you're convicted of all of these charges, this is the range of sentencing you're looking at trial. That basically, if you go to trial and lose on 100% of the evidence, on 100% of the charges, you're going to do 10 to life, 15 to 20, 1 to 5. I mean, there will be a range usually, okay? So your attorney has to tell you that. This is what you're looking at. The worst case scenario is this at trial. Your best case scenario is this at trial, right? And then also usually your attorney can also give you kind of some estimations as to, okay, they have, I know there's like 10 charges against you. I'm pretty sure that, charge count 5 and 7 they can't make because of this. They don't have enough evidence on this one. They can always make all of them. They convince a jury. And if they make all of them, this is your range. A more realistic range based on what I'm seeing, what could happen at trial is you're going to get convicted of 5 out of 10, and this is what you're looking at, right? And your attorney can give you some idea of what you're looking at if you go to trial and lose, and what could be the potential actual loss at trial if not 100%, right? You will then look at your plea. The plea offer will have a charge that you're pleading guilty to, or charges, maybe some priors or some aggravators they'll want you to also plead to or accept. And then there should be some form of applicable range to the sentence. It'll say if probation is available or not, stuff like that. And then you compare, right? So if you're looking at trial, 100 years in prison, and the plea is giving you 1 to 5 years of prison, well, that's something you need to consider, right? Like, the differences are pretty dramatic, right? But if you have a plea that says, well, you take this plea and go to jail for 30 days, and you go to trial and lose, and you're going to go to jail for 30 days, and the fines are the same, and everything's the same, well, probably that's not a very good plea. So you need to sit down with your attorney and analyze it. The most important thing you need to understand is this. A good plea offers you something you cannot get if you're convicted at trial. What does this mean? So if you go to trial and lose, and your consequences there are the same or almost the same as the consequences in the plea, that's probably not a very good plea. I'll give you an example. Standard. DUI plea standard, usually they'll offer you a 1-day in jail plea on a first-time DUI. But if you're a first-time DUI, you're probably going to get a 1 day in jail anyway. Unless there's other charges they're dismissing, that's probably not a reasonable plea offer. So it just depends. And I'm not saying don't take a 1-day plea, okay? I'm just saying sit down, talk to your lawyer, and analyze it. But if the plea that you have and losing a trial have the same consequences, that is not a good plea. It's not a good plea because you don't need the plea to have that outcome. The plea has to give you an outcome you can't get on your own if you lose a trial. That's what a good plea does. And there's some prosecutors that are really good on walking that line, right? They'll give you a plea that's just good enough to maybe not, some prosecutors are really good at finding that sweet spot. And they're basically like, I've told my clients when we get those pleas, I tell my clients, I see all the reasons why you should say no, and I see all the reasons why you should say yes. And that's a very difficult decision because you're kind of in the middle. You kind of just don't know, right? Because it's a very hard decision, especially if you're looking at a lot of time in prison, right? A good plea, for example, another example of a good plea is if, let's say, you have a historical prior felony conviction that basically makes you ineligible for probation, okay? So let's say you had an old felony, maybe it's not a historical prior necessarily, but it makes you at least a category 1 repetitive offender, which basically means you don't get probation. So what happens? Well, if they offer you a plea that allows you probation, that's something you should consider because the judge will not have probation available at sentencing. The judge will have, 1 to 5 years or whatever it is, depending on your charges, depending on a bunch of things. But let's just assume it's 1 to 5 at sentencing, right? At trial, if probation is not available to you. You're going to have to do some time. So if they offer you a plea to the same charge, but they won't allege it's a prior, that means that you would be sentenced as a first-time offender and therefore be eligible for probation. That's a decent plea. That's something you need to consider and talk to your lawyer about. I'm not saying take it. I'm saying talk to your lawyer about it. And, one of the things you can talk to your lawyer about, if they're offering this off the bat, can we make it better? Maybe you want to set up a settlement conference or something like that and see if you can get a judge to mediate between you and the prosecutor and get a better deal. But definitely that's a plea you need to consider. So what is the role of your attorney? This is a very important thing. The decision is only the defendant's, the accused. Your lawyer should never make the decision for you. Never. He or she will not be doing the time for you. My clients always tell me, what would you do? Dude, I'm not the one who's got to do the time. I don't know what I would do. I'd be scared just like you, right? I'm pretty sure I might even be more scared than you. So I don't know what I would do. I don't know what would happen if I was in that situation. Clearly, I would have other considerations different than what my clients would have because everybody's different. But I'm not the one who's got to live with the consequences of them. So I never tell my clients what to do. And your lawyer should never tell you what to do. What your lawyer has to do is tell you, look, you're looking at this and you're looking at this. These are your options. These are the potential consequences of these are your decisions and the potential consequence of each decision. I think this plea is a good deal. I think the plea is not a good deal. You need to make a choice on that. But if you ask me, I think it's decent because it gives you something you can't get on your own, right? Or I would tell my client, that plea is the same plea as losing a trial. It's not a good plea. If you don't want to do trial, that's fine. Sometimes when you have something like that, sometimes you just want to you want to just plead to the court. Screw it. Don't take that plea. Just go into court and say, Your Honor, I want to plead guilty, and have the judge sentence you. Because sometimes when prosecutors make those pleas, sometimes they have some required sentencing conditions and stuff like that. Like, for example, I remember I did a DUI once. They wanted probation as part of the plea. I said, hell no. So we just pled it, and then he didn't get probation. So sometimes pleading straight to the court instead of taking the plea is better. So you need to talk to your attorney to determine all those issues. There's a lot of factors that need to be determined, but your attorney does not make the decision for you. That's your decision and yours alone, okay? Your attorney's job is to give you all the information you need to make an intelligent and informed decision whether to accept or reject that plea offer. That is his or her job. He should not be making that choice for you. He can give you and should give you his opinion based on the evidence, based on the facts and your exposure, and tell you, okay, look, the plea is good because of this, it's bad because of that. These are the things that I see in the plea. These are the risks, benefit analysis that I see in the plea. This is what I've seen with people who have gone to trial on these type of charges. Based on the evidence, well, this video is problematic, but maybe we have a motion to preclude it, stuff like that. So that's what your attorney should do, but the decision is always yours. Okay? Always. Now, there's some myths, some really weird myths out there about pleas, okay? One of the things is that innocent people do not accept pleas. That's not true. There's such a thing as a no contest plea, for example. Under that plea, basically what you're saying to the judge is, I'm not admitting that that's true, but I think they have enough evidence that could convict me, so I'm not going to fight it. An innocent person would do that, especially depending on the exposure. The effects of a no contest plea are, in the criminal context, there's no difference. You're still found guilty, you still get sentenced the same way. But by not admitting that, you are limiting some civil liability if somebody wants to sue you after, right? Another myth is, I'm entitled to a plea. No, there is no right to a plea. You are never entitled to a plea offer. You more than likely will get a plea offer, but you're not entitled to it, okay? So the prosecutor doesn't have to offer you a plea. Another common thing I hear is you should wait till the third plea. The second or third plea are always better. It happens, sure, but it's not necessarily going to happen. I've had cases where my client rejected a plea and they never offered him another one. We had to take it to trial. The one I'm thinking we won it, but we had to take it to trial. They just refused to offer him another plea and said, we're going to go to trial. Okay, let's go to trial. It just depends. You do not have a right to a plea. And if you don't accept the plea, there is no guarantee you're going to get another one or even a third one. If you say no to a plea, you need to understand, saying no to a plea, you have to accept the risk that there will be no other plea presented to you. Okay, so that's one of the things that your attorney and you need to talk about. Some people say, if you don't plead it out, the judge is going to punish you or the prosecutor is going to punish you. No, you have a right to say no. You have a right to put the state to its burden of proving that you committed a crime. Okay? If they can't prove it, you walk. But I've never, ever seen a judge punish somebody for rejecting a plea. I've never seen a judge punish anybody. I've seen prosecutors not offer another plea. If you want to call that punishment, I don't think so. That's their discretion. That's their prerogative, right? So they don't have to offer you a plea. And they will tell you that, right? So the decision is yours. It's not punishment. When you reject a plea, you make a conscious choice and a conscious decision of risking not getting another plea. And those are the considerations you have to have when determining whether taking up your case to trial or accepting or negotiating a plea. If you or somebody you care about is facing criminal charges and you need somebody to talk to, my contact information and my booking information is in the link below. Feel free to give me a call or book a consultation with me. I'll give you a free consultation and we can talk about your case and see if we're the right fit. Okay? Good luck with your case and see you in the next video.